Now, what did Mr. Fikre do in response to this revelation from the FBI? He filed a lawsuit. Fikre avers that these events damaged his reputation by stigmatizing him as a suspected terrorist and so strained his marriage that his wife divorced him while he was stranded outside of the country. Fikre brought the instant suit against the government, raising a variety of common law, statutory, and constitutional claims. As relevant here, Fikre alleged that the FBI violated his right to substantial due process by depriving him of his liberty interest in his reputation and international travel, and by conditioning his removal from the no-fly list upon his agreement to become a government informant. Fikre's complaint also maintained that the FBI denied him procedural due process by placing and keeping him on the no-fly list without adequate notice and an opportunity to be heard. Fikre prayed for injunctive and declaratory relief for both due process claims and asked, among other things, for a declaration by the government that he should not have been added to the no-fly list. The court noted that Fikre's original complaint contained 16 causes of action, but the appeal only dealt with his due process and Fourth Amendment claims. This is where the next twist in our saga appears. The defendants moved to dismiss the operative complaint and, shortly thereafter, notified Fikre that he had been removed from the no-fly list. In a joint status report filed at the district court's direction, Fikre agreed, to the extent he sought an injunction requiring the defendants to remove him from the list. That claim was moot. Fikre contended, however, that he remained entitled to other injunctive and declaratory relief. Now that they're being sued, the FBI removes Fikre from the no-fly list, then claims he no longer has a cause of action because he's not on the list anymore. The Ninth Circuit Court noted, the district court subsequently dismissed Fikre's remaining procedural and substantive due process claims in a detailed decision. The court reasoned that the government's removal of Fikre from the no-fly list was a sufficiently definite action to render his claims moot. In reaching this conclusion, the district court observed that the defendants had publicly stated that Fikre was no longer on the no-fly list, that more than 6 months had elapsed since the change in status, and that the record did not indicate a lack of good faith on the government's part. The district court also emphasized that the courthouse doors will be open to Fikre were he to be reinstated to the no-fly list in the future. Not only did the district court ignore the consequences of the FBI placing Mr. Fikre on the no-fly list, it actually claimed there was no lack of good faith on the government's part. To my knowledge, the FBI has yet to produce any evidence of probable cause that Mr. Fikre was ever a threat to air travel or national security. Furthermore, the FBI tried to extort Mr. Fikre to become an informant in exchange for not only being removed from the list, but being allowed to go home. There's also testimony that the FBI engaged a foreign entity, the United Arab Emirates, to detain and torture Mr. Fikre in what appears to be an attempt to circumvent U.S. law and the Constitution. How much bad faith does the district court need? We reverse the district court's dismissal of Fikre's due process claims and remand for further proceedings. Now, in 2018, 11 years after his saga began, the Ninth Circuit reversed the district court's decision of mootness. This means the case went back to the district court to be heard. Now, one might hope that Mr. Fikre's ordeal was over, but no. The district court again found Mr. Fikre's case moot, although with a few modifications. Once again, Mr. Fikre appealed to the Ninth Circuit. The panel reversed the district court's dismissal on mootness grounds of Jonas Fikre's substantive due process and non-stigma-related procedural due process no-fly list claims, vacated the district court's dismissal of Fikre's stigma plus procedural due process claim, and remanded to the district court to consider, in the first instance, whether Fikre stated a viable stigma plus procedural due process claim, considering both his past placement on the no-fly list and his alleged inclusion in the terrorist screening database. While the district court separated the stigma-related and non-stigma-related claims, the circuit court pointed out, the panel held that because the government failed to follow the instructions given by this court the last time Fikre's case was before the court, the district court erred by dismissing as moot Fikre's no-fly list claims. Now, what did the government fail to do? In Fikre 1, the court held that an exception to mootness, the voluntary cessation doctrine, applies to Fikre's no-fly list claim. On remand, FBI Supervisory Special Agent Christopher Courtright filed a declaration in support of the government's motion to dismiss. The panel held that the Courtright Declaration did not provide the assurances specified by FCRA 1 as adequate to overcome the voluntary cessation of mootness. The government has assured FCRA only that he does not currently meet the criteria for inclusion on the no-fly list. It has not repudiated the decision to place FCRA on the list, nor has it identified any criteria for inclusion on the list that may have changed. Because FCRA 1 governs, the district court should not have dismissed the no-fly list due process claims as moot. So the FBI basically said, whoopsie, and thought that would get them off the hook. Well, the Ninth Circuit didn't buy that, and since the FBI did not buy the Ninth Circuit's opinion, they appealed to the Supreme Court.